YouTube, it's Tone back with another one for you. This one I think you guys are gonna love. I've gotten a lot of questions and a lot of requests in my email for a lot of information pertaining to this particular subject. I don't really have the time to answer everybody's email. That's why I'm gonna just do a video on this. Now, all right, so this is from, and so this is basically pertaining to the bills of exchange, the UCC, and things like that, and how to get it all done. I found this PDF online. Shit is free. If you need it, send me an email. Shit is free. And awesome information. So like this, share this, get this out to as many people as you can, because this is really valuable information. I think it'll help a lot of people get out of the slave debt trap that they have us all in right now at the moment. All right, so this is gonna help a lot of people, so that's why I'm doing it. So right here up top, this is from somebody called Chief Cortland Kalani L at iselflawandmaster.com. So that's where you can find more information pertaining to this particular subject here. So it says Fast Track File, the Admin Process, and Getting Out of Debt Edition. So what do we got? And forgive our debts as we forgive our debtors. Matthew 6:12. So, disclaimer. The material in this essay is for educational purposes only and not to be construed as legal advice about what you should or should not do. The information herein is to assist you in performing your own due diligence before implementing any strategy. This is a continuance from Fast Track File Part 1. If you have not acquired that document from iselflawandmaster.com first, we highly recommend going back and doing so. And maybe you guys want to go ahead and do that because you want as much information as possible. Don't just take it from one source, even from myself, and run with it as if it's facts and shit like that. You want to get as much information as possible and go ahead and filter through and see what you even think that you can do. Because everybody really can't do this either. Some people just don't really have the capacity. You know what I'm saying? And I'm actually available to help with as much of this as I can too. So I offer consultations and things like that too. If you guys need them, let me know. So right here in the link, it's got the link to the dude's website and the free PDF book, the redemption manual. I have that as well for free. If you need the redemption manual, hit me up. I'll send that to you. So definition of debt discharge. The cancellation or forgiveness of a debt discharge results in taxable income to the debtor unless the forgiveness is a gift or a bequest. And now to be clear, the reason why he's saying this is because you can do it a few different ways. This particular way involves a 1099-C. My book, Magic Money Mechanics, #1, teaches you how to do the private money orders. You don't have to do any 1099s and you don't have to pay any taxable income on that particular type of discharge. This type of discharge, you do have to pay. Basically, whatever you discharge is going to come up to you as taxable income. So then you'll get taxed on that income at whatever the rate is. So brief background. First and foremost, with the process we provide, one must be a secured party who has effectively set up their UCC contract trust account with the Treasury before they can start utilizing security instruments to discharge debt. I'll start off saying there's 1,000 ways to skin a cat. Discharging debt is not so much about a specific process, but more so understanding the situation at hand. First, let's start off with the law and understanding that nobody can give you a charge without offering you a remedy. There's always an administrative process. For example, nobody can just serve you with a paper saying you owe them XYZ without first giving you the proper due notice in advance to speak for yourself in fair justice. In a sense, that's your remedy. So this is a big part of it too. You got to get your UCC 1 and 3 filed, your security agreement, and set up a contract trust with the Treasury Department. I offer all of those things. So if you need your UCC 1 set up, email me and we can get that started for you as well. And now I do have it as well, all of the Treasury Pack documents and everything. I have it from UCC 1 information all the way down to where you can set up your Federal Reserve brokerage account and all that. I have all that information that comes with the UCC 1 process that you get done through myself. So what is due notice? Due notice is the information that must be given or made available to a particular person or to the public within a legally mandated period of time so that its recipient will have the opportunity to respond to a situation or to allegations that affect the individual's or public legal's rights or duties. It's important to remember that your future discharge presentments to creditors will be a proper due notice that they are mandated to follow. If they do not respond within 72 hours, it is a contract agreement by law. That's the key to remember. And this is what I've been telling you guys for a long time. You got to get familiar with the administrative process because this is how sovereigns hold court. We don't walk into these people's buildings. We send them certified mail and affidavits and put them in their fucking place. Real simple. So now let's move on to why you have the ability to discharge debt and why being a secured creditor is important. Always remember in commerce, if someone brings a claim or charge against you, they must also offer a remedy. In the case of dealing with the creditors, your remedy is your ability to discharge the debt against you with something called an exemption account. The exemption account is the concept of having an exemption from having to pay for anything because there is no money of substance with which to pay. The exemption can also be thought of as an accounting of what the government owes us for everything they have taken from our parents and us without giving us valuable consideration in return. And we can get into that shit because it's pretty fucking ridiculous, but I'd rather not. So this is why properly setting up your estate with the IRS following the steps in the Fast Track File Part 1 is so important. When you have arranged your affairs with the Treasury acts as your accountant, giving you access to your Instrunments bond as an exemption to discharge debt against your estate. All right, so and that's exactly how all this shit works, just so you know. And if you need help with that process again, let me know. So remember, you have effectively filed your non-UCC transmitting utility lien. You will now become the first lien holder on your estate's property with a multi-million-dollar lien, meaning no one can charge your estate with an obligation without first settling your million-dollar lien secured by your bond. For example, when you're a secured party creditor, companies like Wells Fargo cannot charge you XYZ for a school zone without first paying off the million-dollar lien secured by your bond. So what happens to their debt claim since the creditor's charge amount is smaller than your transmitting utility filing lien? Simply put, your lien absorbs the debt to discharge the obligation on behalf of your treasury bond. So that's how that works. Basically, what he's trying to say is that, you know, and so this works even with criminal charges as well. So because ultimately behind the scenes, all these criminal charges are commercial matters. So basically, if whatever they're charging you with is less than the amount of the lien that you put onto your all caps estate, it means that basically just bounces right off. But you do have to put them on notice. They're not just going to know because you filed your UCC1. Even though that is public notice, you may have to notice these public officials individually if that needs to be the case. So let's understand bonds for a moment. As briefly explained in the first track, file part 1, your birth certificate, social security, etc. is all tied up in a treasury bond that was put on the stock market at your birth and is now currently worth millions or billions. Every 14th Amendment U.S. citizen is livestock being traded on the... It's fucking crazy, right? Every 14th Amendment U.S. citizen is livestock being traded on the commercial market every day. And now you are gaining control to change all that. In the first track file, we will teach you how to authenticate your instrument and take control of your bond in commerce. The key is to use that big $1 million strawman bond to discharge smaller commercial claims, which are also bonds against your estate. So here there's an example of a bill here and things like that. So the account number is a bond, an agreement, obligation between a corporation and your corporate strawman name in all caps, not you as a live living soul. And that's one thing that you guys need to know. That every time you see your name in all caps anywhere, they're not making reference to you specifically so much as they're making reference to your trust, to your estate, decedent estate. That's what they're talking about. It's not you as a live living person, and you need to know that. Because this is what they're doing too when they're fucking kidnapping all our kids and shit like that in the child services and all that shit. They do not have the authority to take your physical children. They can only take what they created, which is the all caps strawman name and bonds and things like that. They can't take physical custody of any of us like that. That shit is kidnapping. Know that. So when you learn how to properly utilize your treasury bonds, it is basically a game of big bank takes little bank. And your victorious bond is your exemption to live free of sin, which is debt. The story of Jesus is metaphorical to him dying on the cross for your sins, your exemption, so that we could live free of bondage. So let us remember IRS clause 301.77017 trust, domestics, and foreign. A trust is a United States person, meaning as a trust that is of the United States, we are referred to as their beneficiaries in trust law, meaning we can receive benefits if we know how to access them, and our benefits are our exemptions. Now, one thing you need to know as well is that you can access all of your benefits and you can take whatever benefit that you want, but it has to come directly from the Treasury. You can't go get it from these fucking people that call themselves the state and shit like that, because they're going to fucking rob you. And then that basically counts as you taking a benefit from the fucking enemy, okay? So that's what you're doing whenever you do that. So you go there, you give them a social, and you sign a piece of paper. You assign them to be your trustee, and now they can take whatever they want out of there as their payment while they're fucking you from the back. And that's how that works. So, moving on. So you could say that the current economic system has been set up for our benefit to repay us as the beneficiaries of our trust. And so these are things that they'll never tell you, because they love having you people as slaves and sitting back and drinking and fucking their boyfriend in the ass while they laugh at everybody over here who's fucking running around in circles and they really can't figure it out. This is what they do to you people. So never forget, there is no money. Before we get into the main topic, I want to say a bit about money. I take the position that there is no money, or at least no money of substance, in our current economic system. You may disagree with this position, and there is certainly room for debate, but for the sake of clarity, I will elaborate why I feel my position has some merit. One definition of money is a medium of exchange. If you want to use this definition, then I would have to say that there is money in our economic system. We certainly do exchange money, our Federal Reserve notes, to get the goods and services that we need. But this definition begins to reveal the problem with what we call money. The word exchange means a situation of which equal value has been given between two parties. If there is no money of substance, then an exchange can take place by money of substance. I mean something that has intrinsic value of its own, such as gold and silver. As far as the Federal Reserve notes go, they have no intrinsic value and can be redeemed as intrinsic value at the US Treasury. That's important to remember, because if the government can convert a piece of paper into an intrinsic value backed by a bond, then why couldn't you do the same with your Treasury bond? And this is exactly what we do. Okay, so this is the right that we have as private bankers, because we're all already classified as private bankers. You just don't know that. Okay, and we're all classified as a financial institution, so we have every right to operate accordingly within the purview of the law as far as private banking goes. And a private banker just means that you practice banking without having a banking license. Really that simple. So every day that you get a $1 bill and you put it into your pocket, you just made a deposit as a private banker. You need to know that. So they already look at you as a private banker, and they're just robbing you blind because you don't understand what your position is supposed to be. And this is why I come in. So look closely. As you see, their Federal Reserve notes are simply pieces of paper backed by bonds. Numbers of U.S. citizens, peoples, energy generation are the resources that literally give this U.S. money any kind of value. And that value of each citizen is tracked through companies' W-4s and a Social Security system that attaches a bond account number. The concept of discharging debt is simply formulating a bill, a note, and utilizing that Social Security bond account number pass-through offset account to be redeemed through the U.S. Treasury in lawful money for your debt obligation. Your bond account is worth millions in digital intrinsic value. Now keep in mind, let me just cut it here real quick. So when we do the UCC filing and we create a bond and all that, we're creating our own bonds at that point. Okay, so you don't have to go try to find your QSIP number or do any of that crazy shit. Your QSIP number after we file the UCC1 is going to be your filing number. And that's the number that you would put. Your filing number is going to be your QSIP number. If you ever had to, like, you know, pull out funds or something like that with the OID or whatever, that would be the QSIP number, would be your filing number. So your bond account is worth millions in digital intrinsic value, and using your exemption to discharge obligations is your legal right, provided you are via HJR 192, June 5th, 1933. All in all, when you take possession of your Treasury bond, the concept is not to cash out, but to utilize your credit from your bond to discharge debt. Since the government can't pay us back in gold for what they owe us as secured parties, they must discharge our debt in lawful money, dollar for dollar, by giving us an unlimited amount of credit. Hence, to why we're referred to as secured party creditors. Please understand that the United States owes you this exemption as a beneficiary of a US trust, and it's time that we reap what is legally yours. And this is all facts. You know what I'm saying? Everything that we do here is 100% lawful. All right? So, here we go. So, Federal Reserve notes have no substance, but are redeemable in lawful money through the US Treasury in exchange for a digital gold currency that serves as substance. Remember that. Let's say it is 1900, the year 1900. You own a clothing store. You are selling men's suits for $20. If someone were to give you a $20 gold piece for a suit, an exchange would have taken place. Both the suit have intrinsic value, so parties receive secured and equal value. Now let's update this story to modern times. You have a clothing store and you are selling a suit for $300. Someone comes in and gives you $300 in Federal Reserve notes. AFRN is a note, and those are promissory notes. But what is a note? An instrument containing an express and absolute promise of signer, i.e. the maker, to pay a specified person or order or bearer a definite sum of money at a specified time. Black's Law Dictionary, 5th edition. So a note is just a promise to pay at some future date. It is a debt discharging instrument. A FRN is a pledge on the part of the government to pay a debt. This means that every FRN in circulation is actually a liability of the federal government. It might appear to be an asset to the one holding it, but it just means the government will pay off the debt someday when there is substance. FRNs are backed by the full faith and credit of the United States, all caps, which leads us to the HJR 192 that gives us the right to lawfully discharge debt dollar for dollar, utilizing our $1 million bonds backed by the US Treasury. So it's HJR 192, Public Law 73-10. Keep that in mind, okay? If you ever have to make a reference to somebody about what it is that you're doing and why it's lawful. So in 1933, and with HJR 192, they took all the gold, all the true money, all the property, and instituted eminent domain and property taxes, divided land titles, etc., and instituted the income tax to control the labor of the people. In addition, with HJR 192 is when they instituted the birth certificates to control the people and have future American people become the collateral for the federal government's debts. Yes, that's right. Your birth certificate is the title to your body. It has been pledged as an asset to back US dollars. And here we have a little graph about a few different things. So to summarize the points that have been made here, the only kind of money in our economic system is credit or promises to pay. When you use a credit card, you are using credit, which is a promise to pay. When you write a check, you are promising that your bank will honor it and transfer credits from your account to the account of the party to whom you wrote the check. When you give FRNs for goods and services, you are giving a promise to pay made by the federal government. So all we really have is a promise to pay. There is no lawful money of substance in our economy. When one officially becomes a secured party creditor and lien holder over the bond and record owner, they can lawfully discharge debt dollar for dollar according to HJR 192 and Public Law 73-10. Now that we know that we have the right to do, let's discuss the process of enforcing it. And this is the biggest thing that I think a lot of people don't know how to do is enforcement, okay? Because these people can pretend at any point that they didn't receive it, but how are you going to fucking make them do what they're supposed to do? This is how. So right here. Public Policy HJR 192, Joint Resolution to suspend the Gold Clause standard and abrogate the Gold Clause. So, Joint Resolution to inform uniform value on the coins and currencies of the United States, whereas the holding or dealing in gold affects the public interest and therefore subject to proper regulation and restriction. Whereas an existing emergency has discovered the provisions of obligations to purport give the obligee the right to require payment in gold or a particular kind of coin or currency in the United States or in the amount of money of the United States measured thereby. Obstruct the power of Congress to regulate the value of money in the United States and a inconsistent with the declared policy of Congress to maintain at all times equal power of every dollar coined or issued by the United States in the markets and in payment of debts. Now, therefore, so this is basically saying that nobody has the right, because they took the gold away, nobody has the right to demand payment in any certain species of currency. They have to take the coin of the realm, which is promises to pay and bills of exchange. Really that simple. You know, these people will try to complicate it and call you crazy and all that. I'm fucking reading this law right now in black and white. So you don't have to argue with these people. Just put this shit in an affidavit, and if they have something to say, tell them to put that shit in an affidavit and sign it, and fucking sign it. And they won't. Promise you they won't. So now, therefore, be it resolved by the Senate and House Representative of the United States of America and Congress that every provision in or made with respect to any obligation which purports to give an obligee a right to require payment in gold or a particular kind of foreign currency in an amount of the United States measured thereby is declared to be against public policy. Okay? So it's against public policy for them to demand payment in any certain species of currency. It's really that simple. So using a bill of exchange. Using a bill of exchange to discharge debt. We suggest you be extremely judicious in the use of the BOEs and only use a BOE if it is in conjunction with a conditional acceptance affidavit where the creditor must prove their claims before negotiating the BOE. The purpose of this file is to create documents or bill of exchange, letter of advice, etc. that can be used to discharge debt. A bill of exchange, BOE, cannot be used to buy an item, car, house, stereo system, big screen TV, etc. A BOE can only be used to discharge existing debts. So at this point, we believe that some sort of loan would have to exist or credit used to purchase the item first, and then a BOE would be used to discharge the loan or debt that we discharge rather than pay a debt, because since 1933, we have only the ability to discharge a debt. The basis of all money in circulation in America since 1933 has been a Federal Reserve note backed by no gold. A note is basically just a debt instrument, a promise to pay. Common sense tells you that you can't pay a debt with a debt, a Federal Reserve note, or any other promise to pay. The foundation of our ability to discharge a debt using a BOE in House Joint Resolution 192, June 5, 1933. If you are not familiar with this legislation, I just read it to you, by the way. If you are not familiar with this legislation, you should study it thoroughly. We will use a BOE to transfer creditors' debt claims to the control of our trust in exchange by paying it off with our Treasury bond account. So how creditors respond to BOEs. The most frequent question in mind of anyone who wants to use the BOE is, how will the creditor respond? First, we should say that we don't know a single instance in which anyone has gone to prison for issuing a properly executed BOE, but we must also say that in many cases, creditors pretend that they don't know what a BOE is or are not going to like receiving your BOE, will likely accept your BOE and pretend they didn't receive it, not processing them or acting dishonorably. And I bet a lot of them, because this is the main thing, you have to do we're gonna go over this too as we go down, but you got to do a UCC3 partial assignment of interest to have a public claim on the instrument, and also to be able to transfer your private credits into the public, it has to be in the form of a UCC3 partial assignment of interest. All right, remember that for everybody who already did their UCC1s. All right, you just go into your account, you create the UCC3 and do it like that. We're gonna go over that. So we've said that the creditor in most cases won't like your BOE. This is because they have been accustomed to receiving a lot of interest and principal payments on loans they made to us by lending our own credit to us. Said another way, they have pretended to loan us money, then ask us to pay back with principal and interest, when in fact they loaned us nothing from their own assets, but instead use our strawman accounts. We then use the BOE to discharge the purported debt. We cut off their supply of all profits that they think that they deserve. At this stage in the use of BOEs, it is hard to predict exactly how a creditor will respond, but you need to be prepared for the possibility that they will act as if you had never paid them. And they will do that, all right? So also, before we can discharge any debt, we must first understand that we are the holders in due course, and that's a big thing. Keep that in mind. The middleman, meaning you are the first lien holder and also the decider as to what happens with your estate and claims and charges that are brought against it. As the holder in due course, you can either reject claims in full or accept claims brought against. In the case of discharging debt, we want to accept the claims for their full value so we can discharge them with our bonds. This is the first package going out to the creditors that they will have 14 days to correspond, along with 3 days to legally reject your presentment according to Truth in Lending. So here are the steps in the process. Please make sure to mail all these packages certified with a green return slip. It is highly important. And that is highly, highly crucial. All right, keep that in mind. Because you always want to have proof that they did in fact receive it, and the proof is going to be the green return slip with their signature. So you know that they got it. So how the exemption process works on the private side banking. Number 1, the vendor sends the customer a bill statement. Number 2, customer accepts for value the bill and sends it back to the vendor. Number 3, the vendor sends the acceptance to their personal banking for processing. Number 4, the personal bank exchanges records with the Treasury on behalf of the customer, and the Treasury sends them a certified check, lawful money, from the customer's bond account to cover the charge. In fact, let's look at the definition of lawful money, and it'll tell you right in the definition how the Treasury issues lawful money on behalf of Treasury bonds. Those bonds are yours, people. So right here, lawful money, this is from Google. Definition of lawful money: any form of currency issued by the United States Treasury and not the Federal Reserve System, including gold and silver coins, Treasury notes, and Treasury bonds. So you see how that shit works there. So here you have the discharge package and instructions. So we got the cover letter here. So let's go over the cover letter quickly and see what that does. Just give it a second, it's loading up. All right, so attention, Stephen Munchin. All right, so this is how that's all going to look. So, dear Mr. Munchin, or whoever is the current treasury, the following items are being sent via registered mail to established UCC contract trust account via the tracking number. So inside of it, you're going to have the cover letter, the UCC1 financing statement, which is going to be your filing number and all that, your filing number and what state it's registered with, the bill of exchange, your birth certificate accepted for value, and a 1040 ES, it says that they're going to put in there as well. So that's how they're going to do it. Then you get the notary presentment. You're going to get a letter of advice, certified copy of HJR 192, notice of entitlement rights, and all of these templates are here too. So when you ask me for the PDF, I'll send it to you. You press these links and you're going to have everything you need. You can copy and paste it and get all your package done just like that. Make it real easy for you guys. And it's only because I think that everybody should have equal opportunity to be able to get everything they fucking want in this life. Fuck what these people say. So accept your bill statement. Remember that since we are accepting the claims, that means we are transferring the debt to our foreign trust as our property now and lawfully paying it off in exchange with our bond. In order to effectively add this property to your trust, you must use a UCC3 amendment to amend your original UCC1 filing. You can see in an example below instructions, this A4V accepted for value statement is to be printed or written on top of the statement in the money order. And there's examples here. All right, so you press these links. It's going to show you the 45-degree angle, red stamps, and what needs to be written on there and all that too. So this document is to be registered on a UCC3 with the Secretary of State. Examples of the templates are here. So creating a medium of exchange, aka bill of exchange, when you go into the bank, you don't just say I'm here to discharge a debt with the law. You have to actually use an instrument, Federal Reserve note, bill of exchange, etc., as a medium of exchange. With this BOE, you are basically creating your own form of money or credit backed by the US Treasury that has your bond, your birth certificate. This is the private way of handling debt obligations. Print this on bond paper or certificate paper. Both can be acquired at Office Depot. Again, these are to be used to discharge debt and not to purchase items. And this is one thing that you guys need to know. Because I know a lot of you people think you're going to just do this shit and fucking run off with a car or $1 million house that on a car that you can't even afford to fucking change the brakes on, and in a house you can't even afford to fucking pay the lights in. So really stop, get your fucking shit together before you start doing this shit. The most crucial step, please don't forget this one, the UCC3 amendment filing. Before we can officially use our mediums of exchange, we must first register the instruments or documents through our original UCC1 contract trust agreement with a UCC3 filing made with the Secretary of State. This is important because you are transferring the property, the debt, to your trust, accepting it for value as yours, and the Secretary Attorney General signs off on it, preventing companies' eligibility to foreclose or take your legal possessions. Remember, the Secretary is the highest notary in the land, and once they file your UCC3, they're basically saying your instrument is authentic and to be utilized in their commercial system. Think about it. Federal Reserve notes are only deemed suitable for everyday transaction because the security registers those instruments through the United States Trust that are backed by the U.S. citizens' bonds. In order to fill out a UCC3 properly, follow the templates below. And it's got all the templates here of how to fill it all out and everything, all right? So remember to list the bill of exchange number on the UCC3. So give it a number, serial number, whatever, and make sure you make reference to that shit clearly on your UCC3, all right? So it's no different than using a check or draft or identifying a check number that applies to it. Where I listed 10,412 in the UCC3 example, that's where you put your discharge amount. So the IRS 1099 form can be acquired online for free. And here you see a copy of a 1099-C debt cancellation thing right here. So right here, they got a cancellation of a student loan debt and all that shit right here. So you guys can check that out. I also offer those services. If you guys need anything discharged, hit me up. I do that for a small fee. So right here, you got the IRS forms, 1041, 1041Vs. All right, so these are vouchers that you're going to fill out. It's got all the templates on how to fill them all out here. All right, so you can learn how to do all this shit on your own. Attach a certified copy of your original UCC1. Certified copies can be acquired by the Secretary of State for usually $1 to $5, and you only need copies of the financing statement and not all of the attachments. So attach a certified copy, or you can just download them shits online. That's what I do. All right, so if you have me do your UCC1 and all that, you access everything online. You don't got to send papers out or nothing. You just go in, log into your account, fill out the UCC3, create your instrument, and send it off. If you need help with the UCC filings, hit me up. I got you. Always email discharge packages to 1500 Pennsylvania Ave and duplicate the package to mail certified to the creditor who originally sent you the account statement, and duplicate the package certified to Departamento de Hacienda. So that's the Treasury of Puerto Rico. That's what that is. So have the next mailing packages to the creditor already lined up to ship out, whether they respond or not. Remember, it's always better to use the notary as a third party when doing an affidavit of mailing. Have them mail out your paperwork for you. You can inform the creditor to mail you back at the notary's place of business, or your P.O. box location is fine. So basically what they're saying is to use the notary's address as the return address, because you're going to need a witness for all of these situations, and, you know, just in case these people don't do what they're fucking supposed to. So now here's where things can get a bit interesting. So after 2 weeks, most companies will have already followed the directions in the letter of advice, and now to forward you to forward your bill of exchange to the Treasury again. The Treasury acts as your accountant and works for you. Here's an example of a creditor that processed the BOE properly. And so they got a letter from their place here, Select Portfolio Servicing, which I just kicked their ass in a fucking lawsuit too as well. So since we have sent you a handwritten note into a creditor for payment, only to have them send it off to another appropriate department for handling, that's because an effective BOE is not a form of legal tender created by the Federal Reserve System, but lawful money issued and handled by the Treasury on behalf of your bond. The creditor's company literally sent off the presentment package to the Treasury for processing and are now waiting to receive a certified check in lawful money. This is all pure banking, just on the private side. And these are all things that they forgot to tell us about in school. Get the fuck out of here. They got everybody living like assholes because they don't want to put this information out for everybody. Crazy. So I do my best to be able to get it out. So the customer's bank in this private transaction is the Treasury on behalf of the strawman. And that's what I use. I use the Treasury as my bank. There is no middleman. Now, if a creditor does happen to correspond back negatively to you in mailing without returning your original bill of exchange note, that is a major problem. But that's exactly how you catch them. That's theft. And don't accept a note from them, only the original bill of exchange. Now that's something to keep in mind, because they can't reject your instrument without sending it back to you with a notice of defect with the opportunity to cure the defect. They can't just fucking reject it. And if they do, according to UCC, that shit's fucking discharged anyway. And that's the law. That's not my personal opinion. Not my personal opinion. So what just happened here, you ask? Well, remember, this is all a game, people. Some greedy companies like Wells Fargo will actually take your bill of exchange, cash in on it with the Treasury, then tell you that your instrument was fraudulent, just to convince you to keep being a slave to their debt. They basically just tried to come up and get paid twice off your ignorance. If you let them get away with it, then that's truly your problem. So don't. So during this process, it's important to remember that you are protected by your state's consumer protection laws for sending out certified return receipts to the collection company disputing the debt. Then if the collection company does anything, calls you to collect a debt, sends a billing statement after your proper notice of entitlement and rights and dispute of the alleged debt, then each act is a violation of consumer laws and will warrant X amount of payment from them. The Fed's Fair Debt Collection Practices Act allows $1,000 per violation for acts after receiving your proper notice of dispute to the debt. With that being said, if they respond back in the first 14 days claiming your correspondence was fraudulent, you can start collecting evidence and putting that conversation on the record if you choose to sue in the future. If they do, you can use all this information against them in the court of law, signed and sealed by a notary. Does that sound familiar? Sometimes when you call in, they'll send you directly to an executive office and discharge the matter right over the phone when they know you are fully aware of the law. Regardless, after the conversation, mail and notice and demand to validate debt claim, the templates are in here, to follow up with that paperwork in the administrative process to properly cover your tracks. Again, this is all about what you can prove and personal execution. So this call-in step is optional. If you are going to call the creditors personally, here are some questions you should ask to put on the record for gaining more evidence against them. Now, me personally, I would not recommend that you call any of these people. All right, you need to get everything on paper. But we'll go over this anyway. So first, ask them, where's my bill of exchange note that I sent in? 99% of the time, the creditor will never send your original, not a copy note back, because they truly accepted it and are cashing out on it. You are on the phone with them, don't let them skip past this question. This is how you put your foot on their throats. And if they do not return your note, that is theft and stealing of your property, they can either discharge the debt or be threatened to be taken to court, which none of them will go for. So keep all this shit in mind, and definitely I wouldn't talk to them over the phone. So, and none of them will go for persecution. Apply enough pressure, and some will discharge it over the phone when they see that you overstand. Number two, second, ask them why wasn't a correspondence sent within 72 hours according to Truth in Lending. It's important to have your green return slip. You can use that against them if they return the correspondence to you after 72 hours, and you already have an agreement. According to the Truth in Lending Act, they only have 72 hours to legally reject the claim, according to the Truth in Lending Act, or else it automatically defaults to them accepting the claim. Third, ask them why are they making me pay for anything when that's not a legal method of payment, settling debt obligations according to HCR 192. You can tell them there is no goal to legally pay for anything and that you have a certified copy of HCR 192 right here in your hand that doesn't say anything about paying for debts. Listen to the reply that they tell you. Regardless, even if they did respond back to you in writing, go ahead and send them the notice of non-response and opportunity to cure for not properly responding to your first presentment package, right? Because they're going to start sending you shit that you didn't ask for and all that. Pretend that you never got that shit because it's not what they should be sending you. So you're just going to act like you never got anything because you really fucking didn't. So if or when the creditor did not respond back within 14 days of your first package, being that you gave the creditor proper due notice and they did not respond to you by contacting you back appropriately, they are now in fault. And you can now send them a notice of non-response and opportunity to cure, which is the last time you're being nice and giving the creditors 10 days for the opportunity to cure or to adjust and fix the obligation between you two. So send them the notice of non-response and opportunity to cure. The template's right here, right in the PDF. So, notice of default and declaratory judgment. So after you send in your last package of documents and still get no correspondence after 10 days showing they cleared the debt, or just simply sent you back a rebuttal not answering the key questions of your affidavit point for point in another affidavit, they are now in notice of default, and you can submit your evidence into the district court as proof that you have perfected a claim against the creditor with an official certificate of non-response approved by the notary. And keep this in mind, there is no judge in the world that can overturn a notary summary judgment. So that's how much power that you have by doing your administrative process properly. It's what it's all about, paperwork. All right? So fill out the information in your certificate of non-response document, get it notarized, and all that since the creditor is consenting to an administrative judgment. Notice this template is formatted in a court plead style since you are about to submit something into the court for a judgment. You want it to be presentable. So fill out the template for the notary certificate of non-response and have your notary fill in his and her info as well. File a public notice either at the county recorder or on a UCC3 amendment, giving the public notice of your statement of claim and showing your evidence. Now mail a copy of your certificate of non-response and notary certificate of non-response along with all your evidence from previous interactions as exhibits. All right. So letters, affidavits of mailing to the creditor's office who sent you the original billing statement. Next, take the originals of your certificate of non-response and notary certificate of non-response and file the claim in a miscellaneous case filed in the federal district court for a declaratory judgment. Which can now be done by going down to your district court in person or doing it online. So you guys see what it is, right? And I want you to know that it's not as complicated as you think. You can really fuck these people up pretty goddamn simply, to be honest with you. So the key is to show the judge all the evidence and prove that you have tried to lawfully settle the matter between you and the creditor that defaulted. And now his judgment will legally have to set the record straight. And once you get the judgment, this is how you enforce that claim against you and make it be discharged by the creditor and the bureaus. So this is all about how you enforce all of your processes and your instruments. Okay. So what is a notary declaratory judgment? Declaratory judgments, a judicial proceeding to declare rights of parties who disagree about their obligations. The disagreement often arises from the terms of the written agreement, but can also arise under a statute or other obligations imposed by law. Typically, many creditors rarely respond to any of your mailing requests because legally they can't. What you are doing is building a verified record over time that will show the entities laying claim to your property completely ignored your request and thus acquiesced to their silence, agreeing to the terms and conditions and stipulations stated in the letters that were sent out to them. And that's the biggest thing too. So you can even assign them penalties and all that in your affidavits because you know that they're not going to be able to answer them. So you can really kick them in the balls if you want. So having this verified record in itself is enough to constitute an administrative judgment. But it does not mean that you can immediately go out and begin publicly recording rescissions and other instruments altering to the title of the property without properly completing the administrative process. Because that's what it's all about. Administrative processes, okay? Administrative processes. So here we just have another chart going over a bunch of this. So here you get a certified copy of the filing from the federal district court, and you can send records of this judgment to the credit bureaus with a notice of disputed items and notice to remove derogatory items, which are going to be all the negative items that they put from missed payments and all that fuckery. Get all that shit taken off. So keep your records and files handy in case the original creditor's company sends a third-party debt collector after you. If they send you any more mail and threaten your property after your declaratory judgment, you can send them this intent to sue letter. And you got the templates here, everybody, okay? Everything's here, man. Everything's here that you need to get all this shit done. To get it all done. So right here, keep copies of all correspondence so that you can start your invoicing them for $1,000 per telephone call, letter, and threat. $10,000 per court case if you have to respond to. And look at that. If they sue you, open up an answer and counterclaim, rebutting all their points with your evidence. Always get a counterclaim moving whenever you get a court thing from these people. You know what I'm saying? Add up all of their fucking violations, throw that shit into a counterclaim. If you already have a UCC1 filed, hit them with some trademark violations and counterclaims and shit like that, and that'll all have to be fucking addressed. Okay? So keep in mind that discharging debt is not solely based on if the creditor will permit your exemption, but more so enforcing it through administrative process. You have the power, not them. Also, this process can be used in many commercial circumstances outside of discharging bank loans, mortgages, civil and court cases, but try to keep in mind not to procrastinate and do everything within 60 days of the first mailing date and keep in contact with the creditors. All right? So quick notes to remember. Try not to discharge small monthly bills. And this is what I always tell you guys. Don't be fucking petty, man. This is for real big bills that you just cannot fucking pay. All right? So try not to discharge small monthly services like bill, electricity directly with the BOE. This is because the UCC process at least in Texas, can sometimes take a few weeks before clearing, and sometimes company might try to cut your service off before you can properly execute the process, sending in your first package presentment. This is what I always tell people too. Even with Magic Money Mechanics, the process takes, you know, upwards of a few months. So this is not something to do on your fucking light bill, because they will cut it off. Instead, try using multiple credit cards to pay off small service payments and then turn around and discharge the debt off those credit cards instead. Now, that's an awesome way to do it. You can prepay all your bills for the year with a credit card and discharge the credit card. Fucking simple, right? But everybody wants to make it all complicated. A way to build credit is to take your future paychecks and convert those into secure credit cards. This is because your cash can now be converted into an asset to now get more credit to discharge and reset against. This is all about banking and financing now. But most importantly, it's about knowing the law and enforcing your rights as the creditor. So getting our fast track file 1 is important. You can properly set up your treasury account and bond for discharges. I also offer those services as well. UCC 1 and 3 filings. Hit me up if you need that. We recommend discharging all your family's major assets first, the house, cars, etc. Then use those to acquire new equity lines of credit that you can constantly discharge over and over again. Now, that's an awesome move right there. You know what I'm saying? Because once you discharge your house and your car, then you can use those as collateral to acquire new loans, and then you can discharge those again and again. Fucking perfect. So the name of the game is to build your credit, plus acquire new assets, plus discharge them with your treasury bonds. Use digital lawful money to acquire tangible assets. If one of your secure credit card providers ever decides to close your secure credit card account, then you have no worries, because the bank still has to return your original asset, which is going to be your promissory notes. Since your previous obligation with that company was lawfully discharged and settled according to HCR 192, they can only keep your money if you never return the funds to their institution, but that's not the case if you properly perfect an administrative process. Do not attempt this discharge process with a vehicle or mortgage if you have not properly filed a UCC-1 financing statement to protect you. The UCC is literally a public financing statement showing a lien of you transferring your property debt from the creditor to you, the debtor, approved by the Attorney General. This makes it a lot harder for greedy creditors to foreclose on your property and to try and take your vehicle. Also, keep in mind that the debt collection letter should almost stop immediately after the first package of each bill exchange. Roughly takes about 3 months to mature with the IRS and successfully process your transaction. Congratulations, you are now complete, and even the judge has signed off on your discharge. This document was prepared by G. Cortland Kalani L. of the Nation of Liberation of Wichita. So, thanks to that, gentlemen. So, you guys already know what time it is. It is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.